Thank you, Mr. Priestley. Argument, Mr. Carroll.
Your Honor, there's recognition on the part of the defense that the jury verdict leaves very little room for discretion, but there are some areas that I would like to argue with relating to the Commonwealth's argument as well as the narrative that's been presented. The Commonwealth pursued a theory of catfishing for years, Judge, while having the answers within their grasp with the digital forensics examiner. Behind the scenes, police officers were trying to change the expert opinion, and Detective Miller, to his credit, resisted. In fact, this executive summary that he testified to remained the same except for one new fact, the changed testimony of the codefendant. Commonwealth made a significant effort to diminish the role that digital forensics plays in these and the other investigations. They never called their witness for the Commonwealth's case, and the strategy paid off because the jury saw this as credibility determination between the codefendant and my client. That was a much easier question for them to answer instead of the difficulties of parsing through the digital evidence and other scientific evidence. By making it about credibility, there was no need to resolve such questions such as, if the codefendant did not know how to log into the suspect accounts, who accessed Christine Banfield's laptop on at least 10 occasions when Brendan Banfield was nowhere near the home or the device in question? Second question, how did Christine Banfield not discover the two-factor authentication on her personal cell phone that the codefendant testified that she secured surreptitiously from Christine Banfield and then put it back? And finally, with regard to digital forensics, how was this plan, according to the codefendant, executed on February 23rd, the night before the murder, with Christine's laptop, while within minutes Christine was accessing her work and also shopping? Those questions remain, Judge, and those were incumbent upon the jury to resolve. With regard to the bloodstain pattern analysis, by making the credibility of the codefendant versus Brendan the issue, there was no need to resolve questions such as, why did Joe Ryan have an injury to his hand that would have held the knife? This was corroborated by the medical examiner. Why was Joe Ryan's DNA found under Christine Banfield's fingernails? Why was Brendan Banfield's DNA not present in any of the certificates of analysis of relevance, and why were there no fingerprints of Brendan Banfield? With clear evidence that Joe Ryan supplied the knife, why was it not considered that Joe's DNA was at the juncture of the blade of the knife and the handle, and that Brendan Banfield's was not present on that item? Why was it not considered that Joe Ryan hit Brendan on his back after being shot, and the blood analysis shows it was Christine Banfield's blood, indicative of Christine bleeding at the hands of Joe Ryan? And ultimately, Judge, why did we not hear from the Fairfax PD regarding who Joe Ryan was, or other officers in terms of the Commonwealth's case? The codefendant, even in her testimony and numerous times before that, indicated that she never saw Brendan touch Joe Ryan's body. Your Honor, the jury has spoken, and we must live with the finding, and my client is prepared to be sentenced while these and many other questions remain. Thank you.
All right, thank you, Mr. Kerr. All right, Mr. Banfield, if you could stand, sir. Sir, is there anything you wish to say at this time before sentence is imposed?
Yes.
Okay.
I'm greatly disappointed in the legal system. The system has failed not only me, but also Christine, my daughter Valerie, the Bensons, and the rest of my family. I was found guilty of a crime that I did not commit, but it's actually impossible to have committed the crime, as the prosecution, their experts, and their witnesses have presented. The prosecution and their witnesses' statements do not match the evidence. My rights to defend my family has been taken away, to defend my home and myself. This is a protected right that I'm sure everyone listening here knows they have. My right has been discarded. I'm being sentenced on an impossible set of circumstances. The prosecution's catfish theory was forced on detectives. Detectives did not agree with catfish theory and were harassed, belittled, and then transferred out of their department unwillingly. 3 different digital forensic experts agreed there was no catfish. This includes Fairfax Detective Miller, their expert. This is a quote from his report. The event spanned over a 46-day period from 1/9/23 to 2/24/23. There's no indication that Christine lost control of her devices during that time. Christine is also active with these related specificialities to her during and around the relevant times. Christine also has a pattern of being active on her devices during the relevant times over the year leading up to the period. This will include consistent email and browser activity between the hours of 2300 and 100 hours. Although the not detailed, sorry. Detective Miller's report was sent for independent review to the University of Alabama for peer review. This is a best practice declared for digital forensics. Holly Kennedy of the University of Alabama agreed with Detective Miller's process and finding that there was no loss of device, no loss of dominion and control during this time. When Juliana was questioned about the details of the case, she was unable to verify or remember the information. Juliana did not know the password to Christine's phone, the laptop, the email account, the Telegram, or the FetLife accounts. She did not even know the name of the email account. How could she have accessed it without any of that information? Juliana claimed that she wrote messages but could not identify a single message that she wrote. Juliana said that the Gmail was created on the laptop when it was created on the phone, then said that I deleted the 2-factor authentication, which was never deleted, never hidden, was still there. The Telegram application was also not hidden, always available on Christine's laptop. It was never uninstalled and reinstalled and was always available. When Juliana was questioned about the email account, this is her quote. I was not the one logging in. It was Brendan who accessed the email. The question was then restated and resent and said again, and this is her second quote. I was not the one logging in. The email account was accessed approximately 10 times while I was not home. This includes when I was in Maryland at FLETC, a secure government facility that required an appointment and ID verification to enter. If Juliana did not enter these email accounts, but they were still logged in, there's only one other person that could access these accounts, and that is Christine. There are also 2 instances where neither Juliana or I were home with the logins. This includes the morning of 2/24, when I had left for work and was seen on video at McDonald's, and Juliana had left the house. Her movements were tracked and verified by GPS. Her phone logged that she was parked in the cul-de-sac, and her Apple Watch had logged her steps leaving the home. And by her own testimony, she also stated that she had left the home. Yet after that, the laptop was then logged in and accessed again. There is no dispute that Joe Ryan brought the knife to my home. My DNA and fingerprints are not on the knife. Joe Ryan's DNA is on the knife, right at the junction of the handle and the blade. The DNA is right where you would expect it to be for someone who is forcefully using the knife. This is further verified by the injury that is on Joe's thumb in his hand. The medical examiner verified the injury on Joe's thumb. Could be caused by the knife. There are no injuries to my hands, nothing to indicate I ever held the knife. Joe's DNA is also under Joe Ryan's fingernails. Sorry, Joe's DNA is also under Christine's fingernails, indicating that she tried to fight him off. Ryan's hands have a mixture of Joe's and Christine's DNA. When he got back up and struck me in the back, it was transferred to the back of my jacket. Juliana's original statement on 224 stated that I never touched Joe. She repeated this both again in both of her proffers and at trial. The prosecution has repeatedly said that I manipulated the scene and moved Joe Ryan. I never left Christine's side. I only tried to render aid to her. Juliana said that I poured blood on Joe. This does not match the findings of the medical examiner or the blood spatter expert, who described that these were transfers and were not as droplets. Christine obtained tickets to the zoo and sent them to Juliana. There was no prompting for this. Christine wrote the zoo on the calendar and in Juliana's schedule. Only Christine could have planned the meeting on 224. The meeting of Christine and Joe was confirmed over a week prior, but only Christine could have chosen 224 because she was scheduled to work. No one else would know that this day would be available. On 224, she had only requested off from work on February 23rd and had not informed anybody else that she was off until then. The Fairfax County Police Department never truly looked into Joe Ryan. No search warrant was ever conducted at Joe's residence. Only 2 women were interviewed about their relationship with Joe, and both found that they were very uncomfortable with him. Both chose not to see him again. One was so uncomfortable that she went to her therapist the next day. These are her quotes. She felt so out of place and that it was dirty and that he was uncomfortable towards her. I believe only one of Joe's friends was also interviewed. He stated that in a confrontation, Joe would choke or strangle somebody. This matches Joe's social media profile, saying that he studied neck snapping at Harvard. And to add to that, where was Christine stabbed? In the neck, which Joe seems to have a fondness for. These things are some of quotes from other people, not from me. Joe had previously also cut another woman. It's in his own messages, in his own words, that he was attracted to that. Separately, there's entire internal affairs videos about this case. So either Detective Bryant or Lieutenant Giacchio is lying based on what they said at trial, because Lieutenant Giacchio denied saying that Juliana was arrested as an innocent. Meanwhile, Detective Bryant said that was brought up to him by Giacchio in his internal affairs video. Both of them are under oath. So one of them would be committing a Giglio violation. Also, Detective Nielsen stated that Juliana was arrested to get her to flip, and there was no other reason provided. Christine was a wonderful and loving person. Just as you heard from many of the people here, she was a loving and compassionate nurse. During COVID, she volunteered to take care of many of the people that were sick and struggling. She signed up for extra shifts. She signed up for vaccination clinics. She cared for her daughter. She enrolled her in dance lessons. She was there for recitals. I loved her very much, despite what you may think of my affairs. Our marriage worked for us. It wasn't something that I looked to end. It was told to other women that I was never going to leave Christine. That was always how it was said. Christine cared very much for her family and friends. I'm not trying to diminish in any way what her life was. She truly was a caring mother, a caring wife, a loving nurse. But I am not responsible for her death. This is not a knife that I ever held in my hand, and I never stabbed her. Thank you.